to the early morning 8:30 show. Today, I've invited a few guest stars over to talk about an issue, and so let me introduce them. First up, we have Sarah. Hello.
Hello.
So Sarah's an activist, and would you like to tell the audience a little bit about yourself?
Hi everyone, my name is Sarah and I'm a huge fan of Lord Danning.
That's nice. Okay, and next up, we have lawyer Jing.
Hi guys!
Hello.
So, I'm a lawyer.
Wait, aren't you like Lord Danning's daughter's cousin's friend?
Yeah.
Okay, moving on, we have Professor Phui.
Hi, thanks for having me here today.
Hi, would you like to let the audience know a little bit about where you're from?
So my name is Phui and I'm a professor from the University of Judicial Precedent.
And last but not least, we've invited a very special guest from America, Kim Kardashian. Okay, so the reason as to why we invited her here today is because recently she helped someone who murdered her sex trafficking abuser out of jail. And we talk about the decision which said, decisions made on point of law by more senior courts have to be accepted by more junior courts. Otherwise, the law becomes anarchic and it loses coherency, clarity and predictability. This statement is basically talking about judicial precedent. So, what is judicial precedent, if you may ask? It is the process whereby judges will follow previously decided cases where the facts are of sufficient similarity or where a case which serves as authority for the legal principle embodied in its decision. And this can be seen in the case of Muhammad v. Barnett, London Borough. The doctrine of judicial precedent involves an application of the principle of stare decisis. It means to follow what has already been decided. This means that any previous decisions made by a higher court is binding on judges in the lower court. Unless there are reasonable grounds for distinguishing the case on its facts, the doctrine has both a vertical and horizontal effect.
Can I add on a bit more to this?
Yeah, sure, go ahead.
England and Wales has a common law legal system which has been established by the subject matter heard in earlier cases, and so is the law created by judges. It originated during the reign of King Henry II, when many local customary laws were replaced by the new national ones, which applied to all and were thus common to all. Scotland has its own independent and, in parts, clearly different judicial system, which its own jurisdiction. The law of Scotland is not a pure common law system, but a mixed system. At present, a result of EU legislation, many modern laws are applicable across the whole United Kingdom of Great Britain and Northern Ireland.
Would you like to tell the audience more about the court hierarchy and structure?
The general court structure and hierarchy is set out below. The final report, the Civil Court Structure Review, was published on the 27th July 2016 and made a series of recommendations intended to inform the current program of wider court modernization being undertaken by HM Courts and Tribunal Service. However, the court system starts from the Magistrates Court, Crown Court, Family Court, County Court, High Court, Court of Appeal to the Supreme Court.
Is there anyone from the audience that would like to ask anything? So to what extent are locals bound by the decision of the higher court?
The general rule is that the decision of the House of Lords binds all other courts, but the House does not regard itself strictly bound by the previous decisions of itself. For example, in the case of Murphy against Brentwood, the House elected to overrule its earlier decisions in the case of Ants against Merton on the issue of local authorities' liabilities in negligence to future purchases of property. The second rule, the Court of Appeal, specifically the Civil Division, holds itself bound by all previous decisions as seen in the case of Young against Bristol Aeroplane. However, this case also identified 3 exceptional circumstances where it could disregard its own previous decision. First, the Court of Appeal is entitled to decide which 2 of its own conflicting decisions it will follow. Secondly, the Court of Appeal can refuse to follow a decision, though not expressly overruled, that does not stand with the decision of a House of Lords. Thirdly, the Court is not bound to follow a decision of its own if the decision was given per incurium. As for the divisional courts of the High Court, they have adopted the rule laid down in Young's case, although judges sitting in first instance are not bound to follow decisions of other High Court judges. Despite so, they tend to follow and do so for the sake of certainty.
Within the English common law system, judges have more authority to interpret law. A judgment contains the facts of a case, a legal position of the reason, and the decision itself. The ratio sets a binding precedent for the lower courts. There is flexibility built into the system for the ability to overrule, reverse, and distinguish to avoid judicial precedent. The first thing I'm going to talk about is overruling. This is said as higher court can overrule earlier decisions of lower court on the basis that it is no longer a good law. This can be seen in the case of Murphy and Brentwood, which overruled the case of Ends and Merton on pure economic laws. The facts are similar to Ends, but the courts didn't allow claim for pure economic laws. The second case is Pepper and Hart, which overruled Davis and Johnson on usage of Hansards in courts. The House of Lords departed from Davis and Johnson and took a purposive approach to interpretation. Lord Denning gave a comment which is groping in the dark without switching on the light. The third case is Conway and Rimmer, which overruled Danton and Camelard on disclosure of documents. The last case is R and Shipuri, which overruled Anderson and Ryan. This is a bit different as there is a difference in civil case and criminal cases. Secondly, reversing. This is when a case goes on appeal and the decision is overturned. This can be seen in the case of Farley and Skinner in the year of 2002. This is a contract case which went from the Court of Appeal to House of Lords. The third one is distinguishing. This is when an earlier case is not used as authority for judicial precedent. In other words, the facts are materially different. Distinguishing also happens when the statement of law in the previous case was too narrow. For example, in the case of Howell Securities and Hughes, were distinguished from Hendon and Fraser and Brunner and Moore. In Howell, the appeal was dismissed and it was stated by the court that the postal rule does not automatically apply in every case. This case was distinguished from the normal postal rule. Also, the case of Balfour and Balfour was distinguished from the case of Merritt and Merritt. This is said as in Balfour, there was no ITCLR, however, there was ITCLR in Merritt.
Is there anyone from the audience that would like to ask anything?
So what would you say are the advantages of junior courts following higher courts division? Judicial Precedent ensures certainty and predictability in the law. In the Oxford Shrivel Lecture, Lord Mann stated that the law should be certain so that it can be easily enforced and so that people can know where they stand. We expect that of Parliament when it frames statute law and of judges when they expound the common law. Therefore, it is submitted that Judicial Precedent allows people to know where they stand in the law and know what to expect in their case. The doctrine also ensures consistency in the law. Because this doctrine enforces that higher court decisions bind lower courts, junior judges cannot make decisions that conflict with decisions of higher courts unless the facts are materially different. The doctrine has been developed and modified to be flexible since the Practice Statement 1966 was established. This made the doctrine no longer rigid. Lord Gardiner LC stated that their lordships regard the use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It provides that at least some degree of certainty upon which individuals can rely on the conduct of their affairs, as well as a basis for orderly development of legal rules. Their lordships nevertheless recognize that too rigid adherence to precedent may lead to injustice in the particular case and also unduly restrict the proper development of the law. They propose, therefore, to modify their present practice and while treating former decisions of this House as normally binding, to depart from a previous decision when it appears right to do so.
Adding on to that, it is also time-saving. Judges do not need to spend time making new judgments for new cases. They can follow past decisions, made if the circumstances in the new and old cases are sufficiently similar. The benefit to new and inexperienced judges in lower courts to be able to rely on the reasoning from the judgment of more senior judges higher up in our court hierarchy. This also ensures that decisions made by senior judges have more binding power as they generally have more experience compared to junior judges. To talk about the advantages, we should also discuss the disadvantages of lower courts following the decisions of more senior courts.
On the other hand, if junior courts are bound by the decisions made by senior courts, it will lead to some inherent drawbacks. Firstly, it would result in rigidity and inflexibility, as the courts lower down in the court hierarchy are bound to decisions made by higher courts. Furthermore, the decisions made by the senior courts in the past may be repeated in future cases, although it has been wrongly decided. Although the junior courts are able to depart from previous decisions in accordance with the Practice Statement 1966, it is clear the freedom is restricted. Lord Denning said that he felt that the rigidity of precedent should give way to justice where the two were in conflict. Moreover, rules which are created from judicial precedents can remain in place for a long time, and they apply even when they are outdated, as change requires a case to come to a higher appeal courts before a new rule can come out. For example, in the case of D&C Builders versus Rees, the Court of Appeal was unwilling to apply the Williams practical benefits approach because that would require overruling a House of Lords decision in Folks and Beer, which is something the Court of Appeal cannot do. Another example is demonstrated in the case of Regina versus Crown, where it took 36 years for this case to overrule Crown versus Miller and make marital rape illegal, thus proving the rigidity of the system. Furthermore, it would also cause complexity and confusion. A case may contain 3 or more separate judgments made by senior courts which are different from each other. As a result, inconsistency may arise when the same judgment contains differing or even conflicting arguments. If junior courts are bound to follow the decisions of the senior courts, it means they have to work out the ratio decidendi for each judgment of a case. Judgments can be long and unclear, and so finding the ratio decidendi is not an easy task. Judges cannot reasonably be expected to be aware of all the relevant precedents which may exist because there are abundant of cases decided by court. The law also becomes complex when cases are distinguished and a new precedent is formed. This is demonstrated in the case of Crown versus Caldwell, where the judge decided to remove the objective test, and in Crown versus G, where the objective test was put back in, which later made the decision in Elliott versus Crown complex.
Another reason why decisions made by senior courts should not be followed by junior courts is it results in slow development of the law. This is because judges are not free to make their own decision, instead are bound by decisions made by senior courts. Judges cannot make law as an immediate response to a community demand or when a general need is perceived. Furthermore, only about 50 cases go to the Supreme Court each year, and only the Supreme Court are in position to give an ultimate ruling on an issue before the courts. It can be extremely expensive and time-consuming to get a case this far. Given the cost of litigation, not all complaints may be prepared to persist with legal action under these circumstances. Therefore, it may take a long time before a case is actually appealed up to the Supreme Court, which provokes changes. The law cannot be changed until a case comes before the appellate courts. According to the Judicial Precedent and Prevention of Contradictory Judgment, an expository study of compliance with judicial precedent in Malaysian and Nigerian courts by Murtalaga Niu Morgan, judicial precedent is a conservative method and does not allow for quick transformation and application of the law in line with the changing situations in society, as many of the principles are outmoded. This stops the law from being updated to reflect the needs of society, as it prevents judges from developing legal doctrines in accordance with societal developments. Moreover, judges are drawn from a more narrow social spectrum. This means their views are therefore less likely to be representative of those in the general public. Moreover, a certain area of the law may have developed over a period of time, yet judicial decisions may not accurately reflect the changes that have been made. This may not be appropriate in modern society, as this seems as though further advancement need to be made. This was clearly illustrated in the case of R against R on marital rape. the courts took the view that the law needed to reflect the society's expectations, and it was only in 1991 that the House of Lords finally overruled that it was possible to be guilty for raping your spouse. This shows that courts are rather late in catching up with modern perceptions.
Adding on to that, judicial precedent also lacks judicial autonomy. This is because the principle of stare decisis states that any court that fails to comply with the applicable law and decision laid down by the senior courts shall have its decision corrected and reversed. And it can be said that system focuses more on compliance with precedent rather than the quality of law and decision, because judges start making decisions mechanically. Furthermore, junior courts are bound to the decision made by senior courts. It weakens the power for judicial independence and accountability among the courts. Is there anyone from the audience that would like to ask anything?
Excuse me, I have a question. So there are so many issues with the lower courts following the decisions of the senior courts. Is there any way to solve that? Answering to that question, for a more holistic and all-rounded analysis of the statement mentioned in the case Wheeler v. Joyce, there are certain issues to look at which lie outside the perimeters of the doctrine of judicial precedent itself. Firstly, on Lord Denning's efforts. Since declarating the ability of the House of Lords to depart from previous decisions in the Practice Statement 1966, the court's attitude towards it was remained rather conservative, and they were very reluctant to put it to application, with certainty being the main reasoning behind it. This was mostly contributed by the phrase "appeared right to do so" that was vague and gave little guidance. In fact, the first usage was 2 years after its creation in the case Conway v. Rimmer, and that was only involved a technical point on discovery of documents. The first major use only occurred in British Railway Board v. Harrington, which overruled Addy v. Dumrack. Only a small number of courts go to the House of Lords annually. Hence, the Court of Appeal played a crucial part in ensuring the strict and consistent application of judicial precedent, particularly in the lower courts. Lord Scarman in Farrell v. Alexander said, "Judicial precedent is situated at the focal point of our legal system. It is responsible for its stability, its consistency, and its predictability." The traditional rule states that the Court of Appeal, particularly in the civil division, is bound by its own decisions and refers to the House of Lords or Parliament if there are uncertainties. However, in the case of Ministry of Defence v. Jeremiah, the Master of Rolls state that a previous Court of Appeal decision should be ignored. This brings rise to Lord Denning's one-man crusade as described in Lord Diplock in Davis v. Johnson. Whilst Lord Denning was the Master of the Rolls, his one-man crusade tried achieving the same status as the House of Lords for the Court of Appeal in terms to the practice statement. In the case B v. B, Lord Denning stated that whenever it appears to this court that a previous decision was wrong, we should be at liberty to depart from it if we think it is right to do so. Normally, in nearly every case, of course, we will adhere to it, but in an exceptional case, we are at liberty to depart from it. Sir George Baker and Shaw Lord Justice were ready to create further exceptions to Young, without dispensing fully the doctrine of stare decisis. Despite so, the House of Lords didn't entertain those arguments. Instead, Lord Diplock addressed it by reviewing decisions where statements had been made in relation to the doctrine of judicial precedent in the Court of Appeal. Lord Diplock dismissed the possibility of more exceptions as suggested by Sir George Baker and Shaw Lord Justice.
Is there anyone from the audience that would like to ask anything?
In America, a common law system is followed. However, the doctrine is more flexible, and appellate courts, both federal and state, have declared it to be their duty, as well as their right, to re-examine and correct their own prior decisions. The United States Supreme Court has squarely announced that, when convinced of former error, this court has never felt constrained to follow precedent. Indeed, the Supreme Court has on numerous occasions, particularly in the field of constitutional law, overruled or departed from prior decisions to the consternation of some conservative-minded lawyers and litigants, as well as some of dissenting members of the tribunal itself. However, there are also numerous other situations in which the Court of Appeals and other courts as well have found themselves bound by stare decisis to follow an earlier doctrine or rule which they themselves might not apply in a case of first impression. This is linked to Judge Cardozo's quote, "Sometimes the commitment to an outworn policy is too firm to be broken by the rules of judicial process."
It hasn't prevented the New York courts from approaching present-day problems with fairness and responsiveness to the current needs. It has not prevented them from breathing new content into common law theories of liability as experience has broadened their outlook and given them a deeper understanding into underlying problems. It has, in general, not prevented them from striving to give full effect to the true function of the common law as a stable regulatory force, but at the same time, as a living organism which grows and moves in response to the larger and fuller development of the nation.
Is there anyone from the audience that would like to ask anything?
So I have a question. How do civil systems actually work? A model of path dependence is formed which the rate of legal claims brought by plaintiffs in past cases affects the future state of the law. This formulation considers a legal system that specifies a minimum level of uniformity in a case. Any set of precedents that falls below a specific level of consistency is regarded as split case law and inconclusive as a source of law. Precedents that reach or surpass a required level of consistency then become persuasive source of law, affecting decisions for future similar cases. In such a system, the state of law is determined by previously established cases and precedents and the flow of recent decisions.
To wrap it up, we can all come to the conclusion that judicial precedent is very necessary and important system as it gives a proper guideline and certainty. Also, noting that the UK's legal system is a common law system, hence, more focus is given to judicial precedent. However, it is a very flawed system as well, and more reformation is needed to improve the current system. Currently, judicial precedent is still very important. However, we are unsure about what the future holds, and in the event that judicial precedent is no longer needed, the court should be ready to discard this system